Welcome, everybody, to today's webinar sponsored by the Coleman P. Burke Center for Environmental Law here at the Case Western Reserve University School of Law. Thank you all for coming for our program on wildlife as property owners. For those of you that don't know me, I'm Jonathan Adler. I direct the Coleman P. Burke Center here. And the Burke Center was founded 2 years ago due to the generosity of our late alumnus, Coleman P. Burke, who was dedicated and focused to environmental questions throughout his life, an avid outdoorsman, naturalist, and dinosaur explorer, or I guess amateur paleontologist, I should say. And we are certainly thankful for the generosity that makes the center possible and programs like this possible. Today, we have an interesting program on wildlife conservation and animal rights and how we might think of these two subjects not only going together, but also combining with property law. We're here to talk about wildlife as property owners, a new conception of animal rights based on this book by our first guest, Karen Bradshaw. Karen Bradshaw, who will be speaking first, is a professor of law and the Mary Sigler Fellow at Sandra Day O'Connor College of Law at Arizona State University. She is also a faculty affiliate scholar at the NYU School of Law's Classical Liberal Institute and a senior sustainability scientist at the Global Institute of Sustainability at Arizona State University. And as mentioned, she'll be talking about her new book, recently published by the University of Chicago Press, Wildlife as Property Owners. Then to comment on Professor Bradshaw's book, we have Professor Holly Doremus, who is the James H. House and Hiram H. Hurd Professor of Environmental Regulation at the University of California, Berkeley, where she's also co-director of the Law of the Sea Institute and co-faculty director of the UC Berkeley Institute for Parks, People, and Biodiversity. She is, among many other things, a fellow of the American Association for the Advancement of Science and a member of the American Law Institute. And a fuller bio of both of our speakers is available on the website. After each of our speakers has delivered their initial remarks, we will then proceed to discussion and questions from the audience. There's Q&A. There's a Q&A box that you can enter questions at any point throughout the program, and we will moderate the programs or the questions through that. Also, for those of you that are attending for CLE purposes, I will be distributing the CLE information at the end of the program, the activity code, and how that is submitted. But now, without any further ado, it's really my distinct pleasure to be able to turn the program over to our first speaker, Professor Karen Bradshaw, who will talk about her book, Wildlife as Property Owners. Karen, the floor is yours.
Thank you so much, Jonathan. It's an honor to be here, and I am humbled to have you hosting this conference and Holly, who is one of my heroes in the field, moderating the discussion. And I promise I'm not just saying that to butter her up, so she will be kind in the comments. I know she is a serious scientist and lawyer and will be very, very neutral, regardless of what I say, but it truly is an honor to be here with you both. I can't imagine better company. So the book, as you mentioned, is basically a radical proposal to reimagine how we address this crisis of biodiversity loss. Now, I'll start by saying what I mean by crisis of biodiversity loss, because there's a wide range of opinions or thoughts on the state of biodiversity in the United States. And I'll be honest, when I started this project years ago, I myself was not well versed on how critical of a time we are in terms of animal loss, biodiversity loss, species loss, and what that means for ecosystems around the world, but also for humankind. And so without delving too far into the numbers, I will highlight a few statistics that collectively show us the state of what we're in. So we know that there are a number of species on Earth and in the ocean that are going extinct at some rate, but the rapidity with which that's occurring is truly shocking. We know that scientists estimate that up to 60% of mammals may be extinct by 2050. We have heard statistics suggesting that unless there is massive set aside of Earth, we might be in a tremendous problem in the future. And so we know E.O. Wilson, the famed sociobiologist, has suggested setting aside half of Earth to prevent this crisis. And we understand that there are reasons to believe that things might be even worse than we understand. A recent study that looked at the biomass of mammals on Earth found that humans and human-owned livestock made up over 95% of all of the mammalian biomass on Earth. which is a truly shocking number, leaving very little of animals. And of course, if you watch the show Tiger King, and who hasn't during this Netflix-ridden moment, you likely know that there are more tigers in backyards in the United States or in the United States than there are roaming free in Africa today. And so the state of biodiversity loss is problematic, not only for wildlife advocates and conservationists who care about natural objects for their own value and worth, but also to anyone who is concerned about the fate of humankind. The book, The Sixth Extinction, highlighted that we are on the brink. Many scientists think we may already be very close to the edge, if not over it, of a stunning biodiversity loss that could be catastrophic to all species on Earth, including our own. So whatever the reason, it seems that biodiversity loss is perhaps an issue that's not receiving the amount of attention that it deserves. And it's easy to understand why. There are certainly many issues that demand our attention today. But because of its silent nature, because there is not a visible person in the news or even before our eyes, biodiversity can get lost. And that's precisely what has happened. In the United States, we have policies that are designed to stem biodiversity loss. But the key tool, the Endangered Species Act, which was enacted in 1970, is not fully doing all that it was intended to do. Now, let's be clear. The Endangered Species Act is important. It has accomplished much that environmental law scholars are enthusiastic about. And yet, the key problem that Congress was looking at when it enacted the Endangered Species Act was a land-based problem. Even then, in the 1970s, congressional history indicates that Congress understood that biodiversity loss, that species going extinct, was attributable primarily to land development. Specifically, when people develop land, animals lose their habitat. This is relatively easy to understand, and the Endangered Species Act attempted to address this issue through the imposition of critical habitat designations. But over time, due to shortfalls in funding, congressional cutbacks in funding, political pressure, and landowner opposition, the US Fish and Wildlife Service has largely failed to do the kinds of land set-asides that are necessary to truly protect endangered species. Certainly, there are some critical habitat designations, but they are hard won. It's very complicated for the agency as a political matter to set aside land, particularly when it's land that is privately owned. And so over time, although it is true that we have had very few species go extinct since the enactment of the Endangered Species Act, the land problem has not been fully solved. In fact, Iris Baverman tells of species that are not extinct, but are kept in habitats in the back of zoos. Are kept in tanks in the back of zoos because their natural habitat no longer exists. There is no wild to which they can return. And as Holly's work has mentioned over the years, public lands are becoming increasingly important for wildlife as private lands become developed. And what has happened over time is you have what is essentially public land serving as zoos, if you will, or areas where wildlife can live freely, but then pockets of individual land development interrupt large habitat corridors or other species-based places where species need to access to live. And it's not the fault of any single landowner. I think this is a really easy point to miss. I just want to make it. It's simple and simplistic, perhaps, to say landowners are the problem with the endangered species. We need to solve the landowner opposition in order to make the species issues go away, right? If we want to solve this biodiversity loss, perhaps we should just be stronger on private landowners. But I included an example in the book, and I think it's important to think about this. Any individual person wants to do the best that they can for themselves and their family. So in owning their land, they're operating on several levels. First as an individual, and then also as a member of society. But when we ask the individual landowner to undertake conservation and habitat-based preservation for endangered species, there tends to be opposition. And even more so for species that are not yet endangered or lands that are not critically designated as critical habitat, you have a situation in which the individual economic incentives to develop land can be so great that they're difficult for the individual to offset. So what does that mean? It's created this very difficult situation where a federal agency, US Fish and Wildlife Service, is trying to conserve private habitat, and landowners oppose it. Now, should they oppose it? I think that that's a complicated question that has many facets. For example, one of the main reasons of opposition is that landowners believe that their land will be less valuable if it's designated as critical habitat, but in fact, studies show that that's not the case. But let's bracket that question for today's conversation and focus on the Endangered Species Act is not working to preserve land to the degree that it needs to be preserved to prevent biodiversity loss. So once we establish that, what other solutions can we look at? And one of the really fun things about being in law is that there is so much creativity. We all have a tremendous number of tools at our fingertips that we can use to craft different solutions to problems. So once we step outside of the box of thinking of the statutory solution of the Endangered Species Act and begin to consider all of the tools that are available to us, it becomes very attractive to think about what other options might be available. We can think about private governance, we can think about state-based or even local regulations. All of these matter, and they're great examples of all of them in practice. But we can also think about sort of non-statutory tools, and that's really the point of this book. It's actually sort of a radical thought experiment. And to be honest, it comes from the fact that I grew up in a very, very rural place. So I'm from McLeod, California. It's a town of 1,200 people at the base of Mount Shasta. And growing up, I spent hours every day out in the forest. And in that environment, I really got to know sort of the rhythm of the seasons and the ways in which different animals interacted. And I came to understand what informs my worldview today, which seems really obvious, but sometimes is easy to forget, which is that humans share the earth with animals. At both the biggest scale and the tiniest scale, we share our environments with animals. So I live in Phoenix, I have a 1-acre lot, and on my lot there are, depending on the time of day and time of season, bobcats, roadrunners, javelina. We just have a number of creatures that are sharing this natural environment. But in the institution of property, right, this field of law that deals with land-based issues, there's no space for animals. We created an artificial reality, if you will, in which people can own property, but animals cannot. And this is completely at odds with the natural environment in which humans and animals coexist. And once we observe that, we can begin to see the effects. And over time, as population has expanded and land development has occurred, what we have seen is a tremendous growth in human land uses and the shoving out, if you will, of animal land uses. And there's no recourse for the animals because they have no legal rights. So the purpose of this project is essentially to imagine, what if we allowed animals to become co-participants in property? And this was a choice, right? At the junction of realizing that it's an error to not allow animals in property, you have two possible solutions. One is just get rid of the institution of property. And there are people who are making that argument right now. That's not my argument. My argument is, let's fold animals in. If we believe that property can be reduced to a theoretical construct in which individuals own, let's just allow the animals to own too. It's not forced redistribution. We're not pushing people off their land to allow for animals, but it's simply expanding the number of options that are available for conservationists. So this could be at a micro level. I could and am trying to title part of my property on behalf of animals. It could be larger scale. It could be on public lands. It could be private lands from benefactors. Wildlife organizations could purchase land for animal if there was key habitat. And then the question becomes, how does this work? Well, the answer is we know how to give non-human entities property, right? Corporations can own property, ships can own property. So it seems relatively easy that animals can own property too. And in fact, they can. In the past decade, most American states have enacted legislation allowing animals to own property and trust. Now, admittedly, this was created mostly so that people could leave valuable belongings to their pets for their care after they die. There are some very famous cases of pets inheriting millions of dollars, but like any creative lawyering, one can imagine a situation where these existing laws could be used to accommodate wildlife trusts. Now, wildlife trusts are one example of how wildlife could own property. In 2009, I presented the book to an audience in Toulouse, France at a Rights of Nature conference back when we could travel. And at that time, they said, but we don't have trusts. We love the idea, but we don't have trusts. And it's actually not the trust that's the linchpin. There are a lot of ways that you can get to the idea of animal ownership, whether it's biological easements that are titled to animals, corporations. One can imagine infinite variations of the ways in which the trusts or animal ownership could actually happen. The fundamental point, and the thing that the book really attempts to do, is to expand our notions of should animals own and why. And so I've given you the basic idea, right? We have this biological idea. There are also some arguments, some litigation-based arguments in the book on how you could argue that this right exists as a matter of customary law. That is either that animals' behavior in and of itself, their territorial behavior, forms a basis for granting them property rights, because it turned out, and I was surprised to learn this, every animal basically that I have come into contact with territorial studies of is practicing behaviors that look very similar to human property. So from ants to bees, orcas to lions, you see creatures all throughout the animal kingdom doing things like forming boundaries, creating mounds in the earth to mark fence lines or to mark boundary corners for the property. And when you think about the ways in which these animals are acting in a human capacity, you have to wonder, are animals acting like humans, or are humans simply being animals when we divide and share resources and space? And in our innovation of law, the purpose of customary law is to look at existing practice before the reign of Richard I and to say that whatever was in place then might still be valid today. Similarly, one could use a customary law argument to note that indigenous practices envision humans and all other living creatures, which might also include plants or waterways, as owning land. And that might be another customary basis. But however one sought to do this, whether it was enacting legislation, pursuing a path of litigation, or frankly, just starting to form trust, which I believe one can do, you can see the variety of ways in which this idea could unfold. But really the point of this project is simply to expand our ideas of why that animals could own and the benefits that might derive from it, which is, of course, stemming this problem of biodiversity loss. So that was a super quick summary. I look forward to your questions, but first I really am looking forward to Holly's comments.
All right. Thanks, Karen, and thanks, Jonathan, for organizing this and inviting me to be a part of it. I've learned a great deal from reading the book and already from this discussion. And by the way, I need to say to Professor Bradshaw, I totally agree on the beauty of McLeod, California, a place that I've been lucky enough to at least be through. I'm very sympathetic to this project. There's no question that extinction, as Professor Bradshaw pointed out, is accelerating because of human actions without sufficient care for the rest of the world. And whether you think non-human species or non-human individuals have a right to exist, whether you think that humans have a stewardship obligation, whether you think that nature provides valuable services to human beings, whether you think that nature is a key part of a fully realized human life, or something else, or some combination of those, the current extinction crisis is and should be a matter of real concern. I'm also quite sympathetic to the desire to reform property law in ways that de-emphasize human individualism and elevate communal interests and the protection of common goods, including but not limited to biodiversity. I congratulate Professor Bradshaw on creative thinking and bold writing. And I also am impressed with the way her work highlights the importance of land to wildlife and conservation, which is something that seems obvious, but can be forgotten or de-emphasized. And also, I think her work emphasizes the importance of robust, long-lasting measures for conservation. There's no question that conservation of biodiversity is a long-term project. It's meaningless as a short-term thing. So it's important to have solutions that will be robust over the long term. That said, it would be really boring if I agreed with everything that Professor Bradshaw has written. So I'm going to emphasize in the rest of my remarks my disagreements. And there are some pretty fundamental ones here. I ultimately disagree with what I take to be the two key premises underlying this project. And therefore, not surprisingly, I disagree with its key conclusion. The first premise, as I see it, is that biodiversity loss is the defining environmental challenge of our time. Biodiversity loss matters. There's no question about that. But the defining environmental challenge of our time is climate change. And in part, that's because climate change is the defining challenge for biodiversity, rather than ordinary land development-based habitat loss. Climate change threatens human communities these days, threatens the fabric of our society, threatens in some places and over time human life. Places like Chicago might become uninhabitable in the next 100, 150 years. That's going to get human attention, understandably, more so than the loss of species. But even more important than that, climate change is fundamental to the biodiversity crisis. And we can't solve the biodiversity crisis without reducing anthropogenic climate change. According to one 2019 study, this is a study by Defenders of Wildlife, a conservation organization. Take it for what it's worth. I haven't looked at it closely, but their conclusion is that 99.8% of the species listed on the US endangered species list are at risk from climate change, among other possible threats. And estimates range from about 1/3 to 1/2 of all species globally being at risk of climate-based extinction. So even if you think biodiversity loss is the most important thing for people to worry about right now, climate change is the most important cause of that. So then premise number 2, modifying property law is the most promising way to address the biodiversity crisis. Well, if you agree with me that climate change is the worst problem for biodiversity, then property law, property ownership, anything about property actually can't be the most important solution. Climate change is no respecter of property lines. It's a serious challenge to any conservation strategy that's based on dividing land rights up between wildlife and human interests. Just ask the managers of some of our most protected lands. In the United States, national parks are usually regarded as the most protected lands. But if you look at, actually, I think you could pick any of our national parks right now and find that they have serious climate change problems. Obvious examples that come to my mind, Joshua Tree National Park in Southern California, it's losing its Joshua trees, the amazing, beautiful plants for which it was named, and it's losing them because it's becoming too hot for them to grow there. And if you look at Yosemite Valley, which is more or less in my backyard here, average annual temperatures there have risen more than 2 degrees centigrade over the last 120 years, scrambling ecosystems and vastly reducing the range of high altitude species such as the alpine chipmunk that don't like to be hot. So the bottom line, I think, is that the best thing we can do for wildlife today is to reduce our carbon pollution problem as quickly and completely as we can. Now, having said that, that's not to say that land-based solutions don't matter. They do. We need to protect habitat at a more local level. I mean, actually, the global way to protect habitat is to try to reduce climate change. But we definitely need more than that. Lots of species were in trouble before climate change impacts became so obvious. Lots of species would continue to be in trouble if climate change ended tomorrow. We need to bring all potential conservation measures to bear. And it is certainly true that conventional habitat loss remains an issue for many, no doubt most of our most at-risk species. Even at this level, though, I have to say I'm unpersuaded that giving wildlife access to property ownership offers sufficient advantages to justify the challenges that it presents. I would describe myself as a conservation pragmatist. I want us to do whatever we can that will work as well as possible to protect biodiversity. And that means not letting the unachievable but highly creative perfect solution get in the way of the perhaps more achievable, if less perfect one. Or put it another way, I judge conservation measures by a kind of cost-benefit analysis. What are the costs of getting there versus what benefits are offered? Or another way to put it still would be, what's the activation energy? What do we have to surmount? What barriers do we have to surmount to get there versus what are the gains that we get by getting over those summits? And because I'm a pragmatist, I tend to prefer incremental, feasible gains over radical change that I think will raise all kinds of institutional and political barriers that we might not need to address. So with regard to the wildlife as property owners idea, I see a couple of key barriers here that would have to be surmounted. The first one, which I think is perhaps underplayed a bit in this book, is that this is a more radical solution than Professor Bradshaw really owns up to, I think, in the sense that, as she points out, we do have versions of property for wildlife. Certainly have these pet trusts, right, where people can leave their inheritance to their pets. That's become pretty widespread. That seemed radical, I guess, to a lot of people not long ago, but it's become pretty widespread. And that perhaps shows us that we can make what seem like pretty fundamental changes to property law. But here, what Professor Bradshaw is proposing is something that's much more radical in the sense that the beneficial owner of property in her conception, I think, is the ecosystem. She says that this property needs to be managed at the ecosystem level, but ecosystems are notoriously slippery things. Very hard to come up with a definition of what's the entity here, and therefore very hard to give that entity effectively enforceable property rights, even if we think the best of the trustees who are going to be doing the managing. And I think there are many examples we could come up with of what does it mean to manage this ecosystem well. One that came to my mind is the Florida Everglades, where the Florida snail kite wants to have the ground a little bit wet much of the year because it likes to forage in shallow wetlands. But we also have the Cape Sable seaside sparrow, which wants to nest on dry land. And so when will the land be dry? How dry will it be? Where exactly will it be dry? Managers have to deal with those kinds of issues, and they're going to have to prefer either the kite or the sparrow in particular locations. Now, I do think in many ways that's a sort of false conflict. It wouldn't exist if people had left more of the Everglades available for all of these species. But at this point in time, we have to deal with it. And so what would it mean to manage for that ecosystem? That's a really tough question to present to trustees. And it's really it's conceptually different than what does the owner of this land or the beneficial owner want or prefer. The second key barrier that I see is how we get there. Anytime we talk about using property law as the solution to our environmental problems or as a key solution, because I don't think Professor Bradshaw's proposing this is the be all and end all here, not at all. But whenever we talk about property law as a key solution, generally that means we have to work at the state level because states define property rights. and have. That's the tradition in our system. Now, Professor Bradshaw sees a strong federal role here. And I'll leave it to Professor Adler, who's much more of a con law expert than I am, whether that is in fact within the constitutional fabric. My guess is that a number of our current Supreme Court justices would find that rather shocking. The idea that the federal government could radically redefine property rights for all 50 states. But even if it could, I'm quite certain it doesn't want to. And I think you can just look at the history of how, how solicitous the federal government has been of state definitions of property rights. If we look at, say, water law, the feds have really been disinclined to override state water law, even when it was clear that they could, because of the property implications there. And it's also clear under the property clause, which you talk about in your book, that at least it's clear to me that the federal government could demand management of lands outside the parks, for example, in ways that benefit the national parks. Under the property clause, they could do that constitutionally. They've never been willing to do that politically. So I think there's just a huge barrier to getting there through a federal push. And then the question is it worth it to go through this kind of activation energy? And it's not clear to me, honestly, what benefit we would get, because people individually and collectively already can and already do, within the existing paradigm of property law, devote land to wildlife conservation. The United States owns about 640 million acres. I think that's about 28% today of the land mass of the United States. States own an additional 200 million acres or so. And that land's not all devoted to wildlife conservation by any means, but some of it is, and more of it could be, right? We could prioritize more of it for conservation, I think, more easily than saying, let's redefine property rights. Even if we look to individuals and collectives, private collectives, the Nature Conservancy claims to have protected some 120 million acres, right? I don't know if that's globally or in the United States. It's a big chunk of land. They've devoted that to ecosystem conservation purposes, is exactly the way I think they would describe what they do with their lands. Ted Turner alone owns about 2 million acres of land. And whether some trustee for bison or for plains ecosystems would do a better job of conserving that land for wildlife than Ted Turner has or not, I think it's an open question. I think Ted Turner's done a great deal without ever redefining property rights, just applying the rights that we have. So I would say, I mean, I guess for me, I absolutely agree there's a serious problem. It needs to be dealt with through how we manage lands. I think maybe for me, it seems more productive to focus on making better use of the existing wildlife or property institutions that we have and our capabilities to acquire and dedicate more conservation lands, more conservation waters. And I think there's a key current initiative that I'd love to hear Professor Bradshaw's thoughts on. It's described often as 30 by 30. Let's conserve 30% of the land in any geographic, at any geographic scope you wanted to define for conservation by 2030. The state of California has formally endorsed that, at least the governor of California has. President Biden has formally endorsed this 30 by 30 initiative. And I'd be really interested to hear how your vision of wildlife as property owners would get us there more quickly and or more effectively than current institutions and legal doctrines. And I'll stop there and we can have some back and forth, I hope.
Fantastic. Thank you so much, Holly. It's very hard to present when one wants to just like write down and think about all the ideas. So I really hope we can have more of a conversation than just strictly responding to points, because that was fascinating. And I appreciate so much your comments. Thank you. I do think that we have more in common than we have apart on this idea. I think we're both conservation pragmatists. I think we have shared aims for biodiversity preservation. For the climate change question, it's a fair critique. I will say I once went to a workshop where a good friend and colleague of mine tried to convince a room of environmental lawyers that water, not climate change, was the defining issue of our time. And I saw how that conversation went for him. So let us say it's a dangerous game to get into the most among environmental law or lawyer attorneys or scholars, because we're all likely to think that ours will win. But I've seen in the animal rights and the animal welfare movement that it's a pity to waste energy arguing between the rights versus welfare, for example, when there's a shared aim of protecting animals. So if I may, I will say your point is well taken. Your arguments were excellent, but I may bracket the climate change aside from just making the one point, which is to say, if we dramatically change the system of land ownership such that some was titled to ecosystem, that would likely have climate change effects as well. But we would have to spend time thinking about sort of the chicken and the egg of what that might accomplish. So I'm thinking over like 50 years, for example, fewer roads might be built through animal-owned lands, et cetera. But let's bracket that if you don't mind, because you raised these 5 amazing points, and I really want to sort of dive into them if we can. So if you don't mind, I'll just sort of give a quick answer, and then I'd love to hear your thoughts, and we can sort of go back and forth until Jonathan tells us that it's time to stop and take questions from the audience, which I do see that there are some questions, so I'm excited to see those. The first question is in some ways the most important, that is it worth it? What is the benefit? And it's interesting because we're in a different moment today than we were when the book was published, even in November of 2020. So one of the things you mentioned is public lands. And I agree, public lands function as an important wildlife preservation ecosystem space. But we've also had the divestiture movement, which is the sale of public lands or the giving of public lands to state, which would then inevitably result in sale. And so public lands are perhaps less secure than they might one time see. We have, as you know, very good private beneficiaries like Ted Turner, but I also think what happens when Ted Turner dies? When that happens, and heaven forbid, but that will eventually happen, the heirs may have different obligations and thoughts than he does. So one of the ways that private property benefits wildlife, I think, is redundancy. I don't want to put all of our eggs in one legal basket. I'd like to spread the risk across different tools and avenues. So adding a new tool seems like only a good thing from that perspective to me.
Okay, Karen, did you want to jump in with some others, or we're going to?
Sorry, do we want to jump in with other questions? Or
We have question people. If people are interested in questions, they can put them in the queue. I have lots. I didn't know if Holly wanted to respond to that quickly. Or,
oh, sure. Yeah. I can say just a couple of things. I mean, as to what's the defining environmental challenge, I agree. Everything's important, right? And everything's hard to separate. I think my key point is that I do think climate change is the biggest challenge for biodiversity. And by the way, for water as well. At least here in California, there's no question that climate change is our biggest water problem right now. I would just say 2 other quick things I wanted to respond to. Spread the risk, absolutely. We're in complete agreement there. We need all hands on deck, every part of our conservation portfolio, and adding new pieces, great. I'm on board with that. And people can choose, of course, where they think they can make the biggest contribution and what they think should be the key priorities here. I mean, we do have a portfolio of conservation tools now, and expanding that portfolio seems great. Ted Turner, by the way, I think his family's on board with what he wants to do with that land. And if they're not, he'll give it to the Nature Conservancy in the end, right? There are ways to deal with that. And I guess I think on divestiture of federal lands and whether this property-based system is a better long-term solution. I do think, like I said, long-term is definitely the way to think. You know, the divestiture movement hasn't worked yet. This has been going on at least since the Reagan era, that there have been strong pushes. It's been 40 years now. There's been a strong push to get rid of some federal lands. And so far, not so much. I think there's actually a lot of political opposition to that. So maybe I'm feeling a little bit better about that. One other thing I wanted to get out there just to ask you is that, as I understand it, you're being careful to say you're not advocating redistribution, forced redistribution of land to wildlife, which I think is a wise stance to take. But at the same time, you are assuming there will be redistribution. And I guess I would love to hear a little bit more about how that will go and what's different from that than the public owners choosing to devote more of their lands to wildlife, or private owners acquiring through conservation easements or other mechanisms.
Great. Shall I respond to that, Jonathan?
Yeah.
Okay, great. It's a great question. So it's interesting, right, to think about the different ways in which property can be shared and why we might think this is a moment. So I will say one of the things that I'm observing in the world now, and this is anecdotal, I don't have a study to cite on it, but it seems as though people are overwhelmed by problems that are so big that it feels very hard to act. And then when there's an opportunity to act individually, suddenly everyone's carrying a straw with them, right? So we both have legislation, but in some states, we also have the straw packet that comes with you to the store. But in either way, having a mix of public and private solutions is reducing the total number of straws. And so at a time when people are feeling overwhelmed, and I've read studies or stories about teenagers who feel, desperate and suicidal given the state of the world and the environmental conditions, I think it's important to empower individuals. And I feel that the property solution allows people who care to do something. I can't solve climate change. I can do a certain amount of activities, but it's a giant sweeping global problem. I can create a conservation trust on my 1 acre of land, right? And so this empowers individual action in a way that I think is really important at this moment.
We have a bunch of questions in the queue. Again, if folks have questions, please put them in the Q&A box on Zoom. There was a mention of climate change, and I'll just note for folks that are interested, here at the Law School, the Canada-US Law Institute is sponsoring a conference on Friday, April 23rd on climate change and the Arctic, profound disruption, uncertain impact. That's a full day event that I think has 5.5 hours of CLE, and the Burke Center is proud to be co-sponsoring that. The Burke Center we're also in the process of scheduling a climate adaptation webinar for later this spring as well. So for those of you interested in climate change, we'll have lots of programming on that. One question that's in the queue, Karen, is that is about how some of the practicalities about how this might work. So the question is, if animals are given property rights, they'll need the ability to sue and be sued. Do you see that role being taken by a public agency, or by allowing anyone to petition the court on behalf of wildlife, with the court appointing an attorney to represent them, particular nonprofit groups? It's a question of how would you see that working, and how might that be different than, say, a citizen suit under the Endangered Species Act?
Okay, so one of the reasons why the trust sort of bubbled to the top of the available array of legal tools in which wildlife could own is because trust law is so old, it is so stable, it is so well developed, and it holds many, if not most, of the assets in the United States. So trust law has dealt with sort of difficult questions about ownership by individuals who cannot express their own interests for a really, really long time. And scientists tend to have the response of like, how do you make these choices? How can you know what an animal would want? How do you deal with invasive species? How do you deal with these competing things? And the answer from sort of a legal perspective is judges have to make impossible choices all the time, right? Who should a child live with? Does an incapacitated person want to continue to be on life support, et cetera, when two family members have different wishes? And so law is uniquely situated to make difficult decisions. And I think in a trust model, the trustees would make those decisions. Now, I also have a concept of the trust being certified so that there's an overarching private certifying body, somewhat like a sustainability certificate from the World Wildlife Foundation or similar organizations that have these overarching certificates. And that might allow economies of scale in the private governance to make sure that the individual trustees, which may be quite small trustees, have access to the information and expertise that they know. And then conversely, that there's a system of private governance with best practices so that trustees agree to be bound by those practices.
And I guess as a follow-up to that, how much oversight do you think a system would need to ensure that, say, if a trust was created to benefit a particular species, that in fact, that is how the trust is being managed? So I'm thinking, say, in the Yellowstone ecosystem, we know that there are conflicts between, for example, how you would manage land to maximize elk herds as opposed to how you would manage the land to maximize wolf populations. And if someone said have a wolf trust, which I would thoroughly endorse, if some elk hunters were somehow able to become trustees, they might change things. And so is part of this designed to address those sorts of problems? And I guess just as a codicil to that question, as you know, and as some of our viewers may know, in the context of conservation easements, there has been concern about whether or not people sometimes use those vehicles or those mechanisms for purposes other than their intended use. So use them for tax avoidance, questions about whether or not the valuations are properly determined and the like. Is your view that this certification would help guard against those sorts of problems, or is it performing a slightly different function?
I certainly hope so. So as you know, conservation easements have been around for roughly 30 years now, and there has been some incredible scholarship. I'm thinking specifically of Jessica Owley, and then she's worked with Buzz Thompson and others to do this sweeping research on the status of conservation easements. And there are so many things that we can learn from that tool for wildlife trusts. One of which is it really helps to have some degree of standardization in the ways in which trusts are developed and run. And so the private governance system can essentially develop that degree of standardization so that the legal tools are sort of readily available and uniformly available to lessen the need for judicial intervention. But then you come up against that question of enforcement. Like, what if someone uses a trust in a way that's inappropriate? What if they say they're doing a wildlife trust, but really they're using it to keep caged tigers and allow hunters to shoot them? What if we see this? And the answer is with property, you very often see these things, right? It's not a perfect tool. It's not a perfect system. Will there be some trusts that are mismanaged or not held in accordance to the best interest of the beneficiaries, the wildlife beneficiaries? Of course. But the benefit of trust that we have over conservation easements and other things is this way in which it's intertwined with both property, right, but also trust law. And so we have fiduciary duties for the trustees that are far more developed in this context than they may be in a purely statutory regime.
Another question from the queue is, does this apply to water or species, to waterways, to species that rely upon oceans or that are ocean dwelling species, river dwelling species? Water rights, especially in the West, don't have the same contours that land rights do. We talk about acre feet of water. We talk about water flows. Does this translate to water dwelling species?
In a word, yes. So I recently published an article in Nautilus magazine, which was my first magazine article ever. I may say after years of writing like an academic, it's hard to write as a journalist. But the article was talking about the ways that this concept could apply to the current UN. It has a very long name, but a UN convention that's basically meeting to develop a proposed treaty for biodiversity preservation in the high seas. And amidst these calls to separate and divide this currently unowned oceanic common, I was essentially advocating for, let's not forget that when we're talking about unowned common or commons in general, animals also have interests in that commons. And the moment we begin to divide it among nations, we're implicitly stripping animal owners of their interests. So that's sort of the oceanic context. With respect to domestic application, the aquatic systems are really interesting, but we do have some evidence that animals are already getting de facto property rights. I believe Holly should correct me because I'm sure she knows more about this than I do, but the Delta smelt is allocated some degree of water rights in California, I believe. I'm looking at Holly for conservation. She may be shaking her head.
No, the delta smelt is protected to some degree by the Endangered Species Act, which has limited pumping of water, but the delta smelt's clearly going extinct regardless. And I don't know how property rights would help it. I think water, the Western water is going to be a real hard nut for your theory to crack, I think. Again, the details vary because this is state property law. There are states where in-stream flow rights can be held. There are trusts that hold in-stream flow rights, and Janice Weiss has written a lot about this in Oregon, which is probably the place where this is best developed, I think. But there are other places where only state or local, only government authorities can hold in-stream flow rights. Now they could be trustees, they can certainly hold them on behalf of species, but I don't see this, I don't know that it would help to say the delta smelt has property rights rather than, and I think this goes back to my reaction in general, rather than there are people who have institutional obligations and who care about the delta smelt, who will devote resources to the delta smelt. And actually, this is one of the few places where the ESA has actually worked under Section 7, although if the presidential election had come out differently, I think we'd have seen the limits of that for sure.
Well, this will make me do some panic Googling after the talk to find what the example I'm trying to draw on mentally. But I think it's interesting, right, to think about percentage allocations to animals. And I want to say that I cite an example in the book where there's a percentage allocation to a specific fish species, but I will have to look it up. I'll be honest, there are hundreds of examples and I can't always keep them straight. I do think, once we open our minds to wildlife ownership, though, we're not just focused on ownership or trust responsibilities. We could also consider questions like, does the public trust require a public trust obligation not only to humans within the United States? I mean, if we begin to radically reimagine these concepts, perhaps there are broader applications.
The answer to that about the public trust is definitely yes, sitting here in California. The public trust in California protects aquatic ecosystems for sure. That's the Mono Lake case. On the other hand, making that matter on the ground, on the lake, has been remarkably difficult.
It is. But I like reconceptualizing. I think pushing on these concepts and thinking about redistribution and equity with other species is difficult, right? Early gains will be hard won, but I also think it's valuable just to shift the mindset around that.
And we have a question, I guess, that relates to that, about how you see what you're doing relating to the broader rights of nature movement. As you may be aware, here in Ohio, there was a municipality that voted to recognize the rights of Lake Erie, and then the state government essentially said, no, that's preempted by state law. But it has been something that has garnered a fair amount of attention here in Ohio. And so I'm curious how you see, and this one viewer is curious about how you see what you're talking about with rights in wildlife as rights holders relating to the broader rights of nature discussion.
Right. So very smart question there. The concluding chapter of the book essentially outlines all the arguments I've made for why wildlife could be property owners. And in fact said, any living thing would likely have exactly the same ownership. So for example, I talk a lot about animal territoriality, but plants use very similar forms of territoriality, right? There's this sharing of space, right? A sharing of resources in a nonviolent way that sort of defines each of these sets of behavior. And so thinking specifically about how that applies to rights of nature, when I say wildlife as property owners, it's in some ways nature as an owner of itself, or ecosystems as owners. And that relates, of course, to this indigenous-led rights of nature movement in the United States. You mentioned Ohio, which is a great example. But one of the interesting things is the valid sort of leading edges of rights of nature in the United States are in fact indigenous-led. So the Yurok Indigenous government of Northern California has declared the legal personhood of the Klamath River. And that, of course, cannot be overturned by state law because the indigenous government is an independent entity. And so thinking about the ways the rights of nature are already in the United States today and how they might, as part of this sort of sweeping international movement, continue to expand and grow, I see this book as an argument in some ways for the rights of nature, but through the lens of property instead of legal personhood, instead of constitutional provision. It's sort of another angle on the same concept.
And we're rapidly approaching the end of our hour. So one other question that was raised is, to what extent should we be concerned about which animal species would be entitled to these sorts of rights? I mean, throughout human history, we've picked and chosen, right? We've selected winners. We like the charismatic megafauna. We might not like some others. Some species we think of as being more beneficial. And certainly when there are species conflicts or interspecies conflicts, even if they are driven by human activity forcing species to compete over what's left over, we make choices. And so does your book or does your approach have anything to say about how we should address those sorts of concerns?
Well, the one observation it makes, and the place where it radically departs from animal welfare and animal rights, is that so much of the current animal focus in law is focused on domesticated species, species that are held in captivity by humans, research-based species, food species, livestock, etc. And wildlife are largely ignored. And so we have this tree of life with the idea that humans are at the top and then less human-like creatures are on the bottom. And this book radically reimagines that criteria, that hierarchy, by saying, I don't know, maybe we're using suspect metrics. Can you echolocate as well as a bat? Perhaps bats are higher. Perhaps we're all a necessary part of a whole. And if that's the case, it's very hard to say that humans are superior. Perhaps we're all necessary. But I will say what I think for the sort of weighing questions, the difficult questions, I do something which I'm going to do right now, which is turn it over to a scientist. And Holly is an incredible scientist and may have some better thoughts on this.
No, I think people are going to pick and choose anytime they have the ability to do so, and they're going to pick and choose based on what appeals to them. So I don't see the charismatic megafauna going away, and I don't see even the most appealing insects really getting their due. Although I'm personally a big fan of the Delhi-Stan's flower-loving fly.
And we will have to end on that note. Thank you all of you for attending today. Thank you, Karen Bradshaw, for writing this book, Wildlife as Property Owners, that could provoke this discussion. Looking at the queue of questions, we could easily have filled another hour. Thanks to Holly Doremus for joining us for this conversation. Again, thanks to all of you for attending. In a moment, I'll be putting up the CLE information for all of you that would like the CLE information. And of course, check out our website for additional environmental programs. I know that if we were doing this in person like we like to do, we'd all be giving our speakers a standing ovation for what has been a very fascinating and engaging talk. We appreciate their time and look forward to being able to host them here in Cleveland at some point in the near future. So thank you both, and thanks to everyone for being here today.
Thank you.
Thank you, Jonathan.